Bhavna from Lexis and Company, working as an intern. Today I'll be talking about review under CPC, which is given under Section 114 of the said Act. In case of review, the party who is not happy or aggrieved with the order of the court can file an application for review in the same court which has passed the decree. This provision has been made so as to facilitate the court to review their own decree or judgment and rectify the same before passing of the judgment. It was held in Ram Baksh versus Rajeshwari Cover AIR 1948 AII 213 that the option of review is still there even if the appeal has been dismissed on any other ground. Order 47 of CPC defines the procedure for the review, which is the decree or the judgment is appealable. However, no appeal has been preferred under the law. In case of no provision for appeal has been mentioned in the law for certain decree or judgment, the Court of Small Causes has passed the decision. The law defines certain grounds on which the review application can be filed. When there are new discoveries of the fact which were not in knowledge or could not produce at the time of the passing of the decree due to the ignorance. In case the error is found on the face of the record and does not require the argument of the entire case again, these errors are not related to wrong decisions made by the court. Any other case in which the case has a delusion can be considered as the sufficient ground. The apex court in case of S. Nagaraj versus State of Karnataka and another 1993 SUPP Clause 4 SCC 595 held that any other sufficient ground has an expanded meaning. An order passed in case of misrepresentation and misinterpretation of true facts can be considered sufficient ground. Time limit. According to Article 124, the time limit is within 30 days from the date of passing of such decree. The decree or order which is passed after the review shall be final and binding on the parties. In case the court does not find any sufficient ground to entertain an application, it can reject the same. The object of this provision is to recall and reconsider the decision before making the final statement. Circumstances when a review petition is maintainable. First is when no appeal lies in the case. According to Section 114 and as held in Ganeshi Lal vs. Seth Moolchand, it was held that taking into consideration subclause C of Section 114, the application of review against a decree passed by small causes court is eligible when an appeal lies in a case but is not preferred, as held in Sitra Mastri vs. Sundar Rama. When the reference for small courts is limitation period for review is 30 days.